Committee. With those words of introduction, I have the privilege in requesting Mr. Sharma to kindly give his presentation. Ladies and gentlemen, please put your hands together to welcome Mr. Sharma for his presentation.
Thank you very much. May I please have my presentation on the... Well, by the time they load the presentation, I'll just once again thank the organizers of the Witness magazine for including a topic on competition law in a seminar on media, which is primarily focused on the copyright and its amendment, as I could see in the first session. Because, yeah. Just a minute. I'm sorry for this. Thank you. Competition law, as we all know, is absolutely a new branch, and for you in-house counsels from various companies related to the various branches of media, I'm sure it must be another devil or another added nuisance, if I can say so, but it's not so. And my purpose of coming to this summit is only to sensitize that it's not only the issues of relating to the royalty or the how the performers or how the authors or how these sculptures are treated vis-a-vis these people who own those rights and how they are maybe exploited or not. It's something broader than this. So I'm going to, in a very short, quick time, because I've been given a very short time, I'm just going to sensitize you on the issues which have come before the CCI till now, and which are very important, you might be reading in the papers, and then to maybe raise certain issues which might come in the future. So the limited purpose of my talk would be just to sensitize the audience on the antitrust or the competition issues which are very much relevant in this sector, as I call it, because it's not a sector, it's a very big sector. Media is not only print media as it used to be, it is electronic media. And electronic media has now expanded to not only the so-called television, but it has gone to internet. It has gone to mobile telephony, it's gone to internet telephony, it is so much enlarging. So we have to see these issues which might come, because this is a very, as I say, this is an emerging area. It's mainly an area where the intellectual property comes into play. So all your content providers, all those who are authors and all, they're basically intellectuals and who are creating day in, day out an intellectual property. Copyright is nothing but an intellectual property. So to begin with, because the time is short, I'll just take you through a very snapshot of what the competition law is all about. This is the scheme of my presentation. I'll just give first an overview of the competition law. So I'll just quickly take you through the competition law. The major branches of this is anti-competitive agreements. Now what is anti-competitive agreement? The agreement between competitors. You're not supposed to be making an agreement with your competitor on what you're going to sell to the public. So that is actually an anti-competitive agreement. A cartel is a worst form of anti-competitive agreement. Then you have abuse of dominant position. It's something like a monopoly, which you might be knowing very well. And then the combination, the mergers and acquisitions. And then this is the organogram of the CCI as of now, as of today. So we have a 7-member commission which is there, headed by Mr. Ashok Chawla, who was the former Finance Secretary of India, and now he's here in the CCI. And there is even a judge, if you notice, Justice Dhingra from Delhi High Court has joined the CCI. So we have a judicial member. We have an economic member, Mrs. Geeta Gauri. Kindly notice, and the others are all very eminent people who are heading this commission. There is a DG who's the investigative wing, and this is the structure which you may not be very interested in. Now I'll just quickly take you through the snapshots of what anti-competitive agreements actually are. There are two kinds, horizontal and vertical. Horizontal are the ones I mentioned just about the direct competitors coming into together and forming a kind of a cartel. And the second is a vertical agreement. So a very quick thought on that. Horizontal agreement, the cases, I'll just refer you, maybe it rings a bell in your mind, cement cartel case. Recently, the Competition Commission of India has fined very heavily for the cement companies who were cartelizing. 6,000 crore plus penalty has been imposed. CCI is now is a dreaded word for even the real estate after the DLF was fined. DLF was given a fine of 650 crores plus. So CCI has become, for those who are, I mean, it's a kind of a bell which should be ringing in the minds of all those, maybe trade associations also, trade associations, I mean, like Cement Association, who are actually facilitating a cartel, That is also because the CMA also has been penalized in this cement case, just to give you a thought. The second kind of agreement is a vertical agreement. That is between the supplier and a distributor. So that is not anti-competitive because that is the business how it runs. But it may have an anti-competitive element if it does something which is mentioned in the act, like tying and bundling, suppose. Exclusivity is also one angle. Then resale price maintenance, if the manufacturers start saying that you will sell at a price which I'll tell, not the price which is determined by the competition or by the market. So all these are things which I just brush in a view. And the penalties you can see are very huge, 10% of the average turnover. And then dominance. Now dominance is something again, it's not actually a monopoly. Dominance in this law is actually different than what a monopoly used to be under the MRTP Act, absolutely different. It's something like it's an economic concept. In fact, I'm reminded of Justice Brandeis of US Supreme Court, since most of you are lawyers sitting here. He used this very good phrase, which I often use in my lecture, that a lawyer who has not studied economics is apt to become a public enemy. So this competition law is actually the basic tool for the free market economy. Because if you have to go by the free market economy, which the world is going, we are all going to the unipolar world, the world which is dictated by a free market so-called economy. The so-called earlier capitalism is gone. So that's all accepted by all of us. So the free market economy, if you have to go by that, then you have to play the role of the game in a fair manner. And that is what competition is all about. So competition law, basically, the purpose is to stop abuse of market power. So the market power is nothing but abuse of dominance in our context. So this abuse of dominance has been seen differently by different jurisdictions. In Europe, they call it by market share, but in the US, it's not only by market share. In Europe, they have a de minimis test. In US, they don't have a de minimis test. It's by the conduct. India has adopted the US way by having a very comprehensive, wide economic definition of a dominant player. It's not like the MRTP, when 25% plus, you are presumed to be dominant. Now, this definition is something which makes all large companies very vulnerable, because this is a per se kind of a violation under the Competition Act Section 4. That's how the DLF was caught. There have been two cases of dominance so far. One is the National Stock Exchange, and I happen to be associated with I was the counsel for the NSE. And the second is the DLF case, in which to some extent I was also involved at the appellate stage. Both these cases are of the abuse of dominance. I'm just giving a flavor, that's all. So cartels, I just mentioned the cement cartel case. Now LPG cartel, there are a few cases which have recently been decided. The dominance, and I again come for a minute on this, is an economical concept. So your behavior, if you are in a position that you are capable of being independent of the competition. For example, T-Series. There's an allegation against T-Series already. And some of my friends from Radio Mirchi are here, the lady is there. I mean, of course, you won a case against them on compulsory licensing. Not against them, but against the society, I know. So T-Series is accused of behaving in a manner which no other competitor of T-Series is doing, because they are charging royalty which are very heavy, which are not the market trend. So can they be abused of dominance, playing dominant position? So the issues, I'm just giving a flavor, because now then I'll come to the actual issues which have actually come up. I'm just trying to give you an idea. So dominance is not by market share, but by your behavior. The way you behave in your market. If it is so strong, if you give so signal that you're so strong that you don't care for what the competitor does, then you can be accused of abuse of dominance. Now DLF had this excuse saying that, well, what I'm doing is everybody doing in the country, because all builders are having the same flat buyers agreements. The clauses are more or less similar. So how can I be only accused of? So the answer the CCI gave was that, well, it may be an industry practice, but even this industry practice, if it is unfair, can be looked by us. So that is the point I just wanted to make. So even if your behavior is as per the industry, so-called, but that industry practice, whether it is fair or not, can also be seen by the Competition Commission. So that is the signal which, the message maybe the DLF case gave to. So just then the last one, the merger control is the last limb of the CCI's purview. And I won't waste my time on the threshold. You can have a look at the slides. And it's very high, the highest in the world. Deliberately, India has kept these thresholds for, approval of the Competition Commission on strategic acquisitions and mergers and amalgamations very, very high. 1,500 crore assets or 4,500 crores, even for individual companies. And for group, you can see. And for out of India, suppose McDowell was to merge with somebody or to acquire, then there's group turnover will be seen all over the world. You can have a look at it. The multinational companies will be seen accordingly. So I stop at this, just an overview of the Competition Act. Now I'll come to the issue which we are going to discuss today. I mean, that's the purpose of my coming here. Now, according to my understanding, the media sector, if I call it a media sector, comprises of these, kindly correct me if I'm wrong, press or print media, television, then you got the films. I'm sorry for the spelling mistake if there are any, because it was prepared in a very great hurry, radio and music, internet and all. Now, I'll demonstrate before you that issues have come in almost every sector of media before the Competition Commission. You may have been reading them off and on, but you will forget. Now, I've just tried to consolidate them before you in a quick, just another 10 minutes, just to give you a glimpse that how there is a super regulator now being built in India, like it is all over the world. It's not that it's only in India, which is actually watching this sector very carefully. So we'll just have a look at it. And I've divided them into two parts. First is the cases under Section 3, that is anti-competitive agreements, and the cases under Section 4, abuse of dominance. And then third limb actually hardly matters because these are the strategic mergers or acquisitions which took place. Recently, the recent one, if you notice the first bullet on the third, the News Corp has actually acquired 50% stakes in the ESPN Sports, which has been approved by CCI only yesterday. So these are cases which I'm not going to discuss, but I'm going to discuss very quickly these cases where the violation has been found. These are the cases where violation has been found. So kindly have a look. So the first case which came to CCI was the Multiplex Associations of India versus the United Producers and Distributors Forum. So these United Producers and Distributors Forums comprise of all so-called who's of the music and the film industry. You had Amir Khan there, you had Shah Rukh Khan there, and you'll be surprised, all these so-called great actors were sitting before the DG once upon a time, and they were actually giving statements. That is the reach. So everybody in the, and what they actually did, there was a difference between the ratio, revenue sharing ratio with the multiplexes. So they said, all right, if you don't agree with our suggestion, what we'll do is we'll boycott you. The films which we produce, as an association we'll take a decision, will not be given to the multiplexes. Now imagine, there are hardly any small theaters in Bombay or in all major metropolitan cities, so where the films will be seen? So this was a huge thing. This was naturally this FICCI. FICCI is an apex chamber, like SHARMA and FICCI. So they said, all right, we'll come to the CCI. This was the first case ever filed in CCI in 2009. Mind you, CCI got powers from 20th May 2009, and this case was filed within a month of that. So this is the first case. And what happened in this case? The DG, investigated the matter, and they did find that there were mails were exchanged between the producers. They were acting in concert, there was a collusive behavior. So there was a collective decision by this independent entity, so-called Yash Raj Films, this film, that film, to actually make a kind of a cartel to boycott, to deny so-called market access to the multiplex owners. So this was the first case where a token fine of 1 lakh was imposed on each producer of the film industry. This was the first case. But then came the next case. Now this was a case, if you would remember, you might have read, this was also in 2010 or something. Reliance, is also into the, Mr. Ashish Chandra is a friend of mine, he must be sitting. They are also into this movie making. They also have a movie, making. So what they did was, they made a movie called Ravan. So what happened, the Karnataka Chamber of Commerce said that, all right, if you don't become our members, first of all, you have to be our members of the Karnataka Film Chamber of Commerce. And only then we can allow you the release of your movie in South India, that too in selected theaters, which we will earmark. This was the kind of behavior. Now, is it not a behavior which everybody will say, what is this? And let me tell you, it's not only Karnataka. This particular second bullet, which I have actually compressed in, there were as many as 15 so-called regional chambers of commerce or films, they were having a similar kind of arrangement. Madhya Pradesh, you had Bhopal, and many places. So they were saying that if you are a distributor, you have first to be my member, then only I'll allow you to be releasing your films in my territory. Films are sold territory-wise. So this case also then went on in the CCI, and they found, yes, there's a collective behavior on the part of these associations. And this time, CCI didn't give a token fine. They gave a fine of 10% of the average turnover, which is the maximum fine CCI can impose on. So on each so-called association, a fine of 10% of the average income was imposed. Now the second case the second kind of category is the abuse of dominance. Now this was the only case perhaps in this sector, and it's very interesting. This case relates to state of Punjab. Now in state of Punjab, this Concern News Private Limited produces a channel called Day and Night News. There's a news channel which makes a regional, it's a regional news channel, which is mostly confined to Haryana, Punjab, Chandigarh, or maybe HP also, Himachal Pradesh. Now, this news channel had an agreement with this Fastway Transcommunication Private Limited. This is an MSO. You know, there is a broadcaster, there is a multi-system operator, and then there are agents, and then there are, LCOs and all that. This is this chain we all know. So this was an MSO's case. So Fastway Transcommunication along with Hathway, there was another MSO. There were 4 MSOs actually involved in this particular case. They all, actually this Concern News had an agreement with them to naturally distribute their news channels and all, the screening. So what the CCI found was that this Fastway Transmission, which is the leader of these 4 MSOs, was actually curtailing the content of that particular channel. How? Because the channel was little forthright. It was giving news which were embarrassing the political establishment in Punjab. I don't want to name. It is a very recent case, and recently the appeal has been filed. So they found that just because the channel is giving news or giving analysis which is not suiting the establishment in that particular state, and that particular family or that particular management is controlled by people who are in the government, so they slowly brought down they started curtailing their news. So much so that earlier when they signed an agreement, the example with me is that 45 lakh subscribers they had. And at the time of going to CCI, they had been reduced to 54,000 subscribers. Because people stopped using that channel. When you're black out totally, you are supposed to be showing a clipping at, say, this prime time, but you're not there. You might wait for 1 day, 2 days, but then naturally people will get fed up. I said, this is not coming. This news channel is out. So they were a complete blackout also of that channel, you see. So this was the stage. So then the CCI imposed, you can see the fine, 8.40 crore on them. It's a decision which has recently been appealed by some people, and the appeal has been admitted only yesterday. It's a very recent decision. So these are the 2 categories of cases which I'm showing which have come before the CCI. And if I can take you to the next bullet. Now, but it's not that every case was actually successful. Now let me give you the second side. The cases which were actually closed, this bullet actually shows you the cases which were filed, but which were not successful. So the first case was on Tata Sky Limited and consumer. This consumer organization filed a case saying that there is a set-top box, if you know STP, which you sell, why it is not interoperable? Why I have to buy a different set-top box for Tata Sky, why for Dish TV, why for this TV, why? Why can't we have a set-top box which should be having an interoperability like now we have in the mobile phones, right? So this was an issue, but unfortunately CCI said no. Technical development has not reached a stage. This was how the CCI closed this case, that you can have an interoperability, and there is not a collusion, there is nothing. We don't see any evidence of their coming together, to dictate this kind of a term, so they closed the case. So similarly, in other cases, on abuse of dominance, the maximum number of, actually yesterday I was asked by a correspondent in Mint, maybe they would have carried my quote today in the Mint, that Mr. Sharma, according to you in the media sector, which violation is more prominent? I said the violation which is more prominent is abuse of dominance, but the violation which is more conviction rate is there, it is section 3. So the conviction rate before CCI is more in section 3 cases, that is the cartelization kind of cases, rather than abuse of dominance, because they are seeing it very carefully. Because abuse of dominance, if I can just share with you a minute, is something which is very vulnerable. All companies are vulnerable. So if you are a dominant player in a way, and for example, your distributor doesn't give you payments in time, and if you stop supplying to him, he will go to CCI saying that they are dominant, they are denying me market access because they're not supplying to me. He will not say that because I'm not paying to them. So those kind of futile or kind of infructuous or kind of complaints would be there. So they are very much aware of it. So in these cases, I'll just quickly take you. The first case was Sun Direct TV versus JK Communication. This was again in, this complaint was filed by this communication. They're saying that the Sun Direct TV is doing predatory pricing. This was in Chennai. This was a case that they're saying this was controlled by the Sun TV, Sun channel. They are doing predatory pricing. They're charging below. And the Dish TV, Prasar Bharati, Dish TV went to Prasar Bharati, said that please advertise my advertisement also on the national Doordarshan. Doordarshan has a vast reach. You are a dominant player. Doordarshan reaches very much. So please advertise about Dish TV's contents also. They said no, we will not. CCI closed this case saying that Dish TV is actually a competitor and Prasar Bharati has its own DD Plus channel. So you can't force a competitor to show something which will be against their own interest. Things like that. So on this ground, there could be issues. If somebody would have approached me, I could have said, all right, there is some issue to file an appeal too. in these cases, but mostly the CCI's order were more or less prudent in the sense that they closed complaints which were actually not prima facie seen to be raising a issue of competition law. Similarly, the ETC network synergy, this was a Run movie, the movie called Run. You might remember there's a movie called Run which said that I'm not being given by this ETC channel, I'm not being given good, ratings. So this was a complaint which was filed. CCI said no. And then BC Arora was a TV channel. This was very interesting. This is a KBC case. Kaun Banega Crorepati, which comes on TV. And this is related to KBC 2. This was actually an interesting case which, according to me, should have gone in appeal. And I'll just take a minute for explaining this case. BC Arora was a consumer. He said, I tried 1,200 times, to log on to you, the KBC, the number which they give. And my score was around 57%. But I was never called on the hot seat. So I find there's a tie-up between Star TV and the Airtel. Because every time I have to do SMS, and it's not only me. There are thousands of people must be doing. Who doesn't want to be crorepati? So this tie-up is actually between the TV and the Idea Cellular or Bharti Airtel in the Star case, and Sony TV and Idea Cellular in the other KBC 4. So this was a complaint filed that these two entities are actually kind of trying to abuse their dominant position, and they are cheating the common man of India, so-called, because we never get to go to the hot seat. So again, CCI closed this case with giving a very interesting reason. But this was a case which actually could have actually taken, because this was not investigated. Mind you, these are the cases which were closed by the CCI at the prima facie stage. There are two stages of closure of the cases before the Competition Commission. One is the stage where they just have a look at it and they say there's no case made out. They just throw it out. They don't refer it to DG. The second case is where they actually refer it to DG for investigation. And after DG comes out with an investigation report in which evidences are collected, then they also can close it. So this was a case where DG had said, yes, there was some violation. There was some evidence of, so even then they closed it. So this could have been a contentious issue, whether they would have gone in appeal or not. And this Anuj Kumar Bharti was, the KBC case. BC Arora was a TV channel, but it was a different case. I'll have to see this. Prince India was another case. This is the latest case in the print media. I think some of you would be knowing Springer. Springer is a very big publisher giant. Now, Prince India was a distributor of books, of scientific and medical and other journals. It was having distribution rights from the universities directly. Earlier, when Springer was not there. Enter Springer. Springer has a co-publishing right. Entered into agreements with these universities directly to have a co-publishing right. And then say, you distributor, you go out. Thank you very much.
Once again, request Mr. Shyam Grover, Group Editor and CEO Lex Witness, to do the honors of presenting a memento as a token of appreciation to our very eminent speaker, Mr. M.M. Sharma, Head Competition Law and Policy, Wesh Associates Advocates. Thank you very much indeed, sir, for that wonderful presentation. And now, ladies and gentlemen, for the next presentation on convergence of technology and related legal. So we have no time for questions. You can kindly write down your questions on a piece of paper and pass it on to the speakers. They'll address to it later on.